Okay, I'm David Hogg, and I wanted to say, first of all, that I really appreciate all of you being here. It's good to see each one of you, and those of you who've come back, it's good to see you again. We always look forward to this time of the year to getting to see y'all and to share information with you, things that we've learned in our practices, and sharing that information with you to hopefully help all of us have better practices. And I wanted to share some things with you today. I'm going to be brief. I know y'all came hoping to hear me give a long presentation, but I'm just going to keep it very short. It's Friday afternoon, and I think we all would like to go be doing some things other than sitting here. But I wanted to share some things with you that I've actually seen work in mediation and that have been effective. These are just some thoughts drawn from experiences that I've had with mediations that we've held over the past couple of years. And they've helped bring in millions of dollars for our clients. And so just a few ideas, and then I'd like to get your input. I'd like to hear you share some of your own experiences too about mediation. And how many of you have ever been involved in a mediation? Okay. Have any of you ever served as a mediator? Amy? All right. Leah? Maybe you could sympathize with this mediator here. The mediator sensed that the negotiations were in trouble, and everybody's giving the other side the raspberry. Sometimes mediations seem like that. The Alabama Center for Dispute Resolution says mediation is a confidential information or informal process during which an impartial third party, the mediator, assists disputing parties in reaching a mutually acceptable agreement regarding their dispute. Well, what ideas I wanted to share with you today concern is trying to maximize our effectiveness in mediation, maximize what we can do for our client. And so many times it's easy to approach mediation with the idea that we're going to settle this case today in mediation. Isn't that the comfortable thought? Isn't that the kind of the default process? We just like to go in there and get this case resolved. Well, if we're going to get the most for our clients, we found that there are things that we need to do up front and throughout the process to maximize what we can actually recover for them, and also their expectations. A person's expectations can color or affect what they see as maximization of value for them. And the first thing we need to do is to condition their expectations. We need to manage what they expect to get out of this case. And when we're thinking of doing that in terms of mediation, when is the best time to start doing that, would you think? When's the best time to start trying to manage your client's expectations of the value of the case?
During the beginning of the presentation.
Would you say from the very first meeting with the client? It's tempting, isn't it, to, early on want to tell a client, boy, this is a great case, I think it's worth, X number of dollars, only to get into the case and find out that there's some problems with it. And suddenly, what you've told your client is worth a whole lot of money. Now you're really thinking that it's not worth quite that much. And so, from the very get-go, we need to be forthright with our clients. We need to help them understand that we're enthusiastic about their case, but we don't need to be unnecessarily or too early out of the gate overly optimistic about the value of it, not knowing what really all the facts are and what the value of the case is, what all the damages are, what the defenses are. And so, there are things we can tell them when they come in and we take the case to start tempering their expectations while letting them know that we still believe in their case. some of the cautions we can give them. For example, here in Houston County, we can remind them this is a conservative county. We can let them know that we're enthusiastic about their case. We're going to have to get all the information. So we don't put ourselves in the position of creating an inflated expectation on the part of our clients, only to have that make the case more difficult to mediate. Well, once we've taken the case, in order to maximize the value we can get in mediation, we need to thoroughly work the case up. We need to do all of the discovery and develop any heat that we can in the case. And you've heard that talked about today. All of the things that can add value to the case by creating trouble for the other side, whether it be the bad driving record of the truck driver, or him being under the influence, or not being really fit to drive the truck, so forth. And then when it's time to mediate the case, you don't want to mediate too early, before you've gotten that discovery. You don't want to mediate too late in the case either. And why is that? Why do we not want to mediate too late? Yeah, they may be irrevocably committed to trying the case. And so when it's time to mediate the case, we want to approach mediation not with the idea that now we're going to settle the case, but we want to have the attitude that this is just another step in the process of resolving this case. And whether that resolution be through a trial or if it's able to be settled at mediation, we're simply looking at resolving the case for our client by whatever means are necessary. And we're going to approach mediation as an opportunity not for the other side to do us a favor, but for us to do the other side a favor and give them a chance to resolve it without us having to go to trial if they want to. Also, we want to select a mediator who understands our case and can help our client understand the weaknesses that they have in the case, and also help the other side understand the strengths that we have in our case. For example, if you're handling a commercial transaction dispute, you don't want a mediator who only knows domestic law. They're not going to be able to help both sides see the issues that are involved and the relative strengths and weaknesses. And so find a mediator who's familiar with that area of law and who can help sell the other side on your point of view, your strengths, your client's strengths, and also help your client understand the areas where they need to have some reality check. When you get to mediation, there's a school of thought that, if we make an opening statement in mediation, it may just tend to, cause the other side to bow up and to shut down, because it's just too confrontational. It causes hard feelings. Have y'all heard that? We don't believe that. If we've got a good case, if there's substantial money that can be recovered in this case, we feel that mediation does several things. One, it gives us an opportunity to communicate directly with the other side. You can't do that. Until trial, you get them on the stand and you cross-examine them. But here's a chance in mediation where we can talk directly to them. Everybody is into visual aids these days. We're all visual creatures. We like to see as well as hear. And in mediation, take advantage of that. PowerPoint presentations. You've seen them today, and I brought a few slides, video evidence from a case we handled, photographs showing OSHA reports. And I'm just going to scan through the type of technology, visual technology that you can use during the mediation. You can narrate and get the point across for the other side to see graphically what they're going to be confronted with if this case goes to trial. okay, video. And having somebody who's really good at PowerPoint, you know, to work you up a presentation, can be a powerful tool. All right? Now, when we're going into mediation, another thing that's important is to evaluate up front your demand. Matt talked about what might be the limits, the uppermost limits of a case, like a wrongful death case. And while there's no fixed or firm rule on what a wrongful death case is worth, if you do some legal research, you can see what, you know, the maximum award that's been approved or upheld by the Alabama Supreme Court has been. And with that in mind, you know that if you go in and you make an excessively high demand, a ridiculously high demand, then they're likely to shut down. And you've hurt your credibility. You've hurt the opportunity to resolve the case in mediation. Develop talking points ahead of time. You know, the strengths of your case, the problems that the other side has with their case. You want to have that before you when you mediate the case and keep it in front of you at all points during the mediation. View that opening statement as an opportunity to look right at the opposing party and talk with them and address them and talk with them about these problems that they've got, the risk that they have if they go to trial. They're going to have an insurance adjuster there or you know, nearby that they can get on the phone. But we found that these techniques can help to put pressure on the business owner, on the executive, to motivate them to get that insurance company and push them to settle the case. Develop a game plan before mediation. Go ahead and plan out. Now, this is a suggestion. This is not a hard and fast rule. But, for example, you could have your first 10 moves already planned out. And you could say that we're going to respond incrementally to each offer that the other side makes by going back to them with 75% of what they offered. So, you know, we've made an opening demand and they come back with a reply. We're going to reduce by 75% of their offer each time for the first 10 moves. The idea is to get them to offer at the mediation all that they've got. We're not there, again, trying to come to a middle ground. We're not trying to get to some predetermined figure that we're going to settle for. We want to get them to put everything on the table, because what happens if we go in there with the idea that we want to get them to a certain point and then we'll settle? What's the risk in that?
Leave the money on the table.
Yeah, they might have more to offer, a good bit more to offer than what you thought your best was. And stick to your game plan once you've made it. Don't vary from it. Don't do something that you didn't plan to do, but try to get the other side to do something that they didn't expect to do. Be honest in your negotiations. If you tell the negotiator or you tell the other side, look, we're not going to take less than X dollars to settle this case, and then you do, what have you done to your credibility? You've damaged your credibility in that mediation, but also in the future. It's a ding on your credibility. And each time you go in to a mediation, there's some lawyers that the other side knows. They're going to settle in this mediation. They settle in every mediation. If they say that they're not going to take less than X number of dollars, you know, they probably will, because they've said that before. So protect your reputation with the mediator, protect your reputation with the opposing counsel. Be prepared to mediate with 3 different parties. The other side, your client, and the mediator. And why is that? Why are you going to possibly need to mediate with the mediator and your own client? Well, y'all have all done it. But what happens when you get into a mediation? What's the We already know the objective of the other side. What's your client's objective? They want to get more. They want to get as much as they can possibly get, even though your view might be, and the mediator feels like it may not be quite worth what they think it should be. All right, and you're not trying to get them to take less, but you are wanting to, again, help temper their expectations. What's the mediator's goal? What's his objective? He wants to resolve the case here in this mediation right now. But we're there to try to get the other side to put every last dollar on the table. We don't want to walk out of that mediation until they've put every last dollar on the table and we've determined that it's not acceptable. Well, what's the mediator feel about that? He may be pushing you to want to just take their offer and get this thing resolved. It's a success for him. And so we've got to be able to negotiate with the mediator and help him understand, that we're representing our client, and we've got to be willing to frustrate the mediator if possible. Yeah, Emory?
Yeah, I had a mediation one time involved a lot of money, and both sides agreed on the mediator. Well-known lawyer from Montgomery, and good reputation as a mediator. You look at an Alabama lawyer, he's with that big group, of mediators. And he was doing pretty much mediation at the time, and he's well respected and all that. But he didn't do anything in that mediation. Mm-hmm. All he did was just tote numbers back and forth between the two sides. Mm-hmm. And it was just ridiculous. We couldn't talk. We would talk to him, but he would not say anything to the other side. And later we did settle the case eventually, not with him. Mm-hmm. But I talked to the lawyer on the other side, and he had the same opinion that we had picked him, and the guy, this plaintiff's lawyer, was saying, "Look, go in there and tell him something, this and that," and he didn't do a damn thing except tote numbers back and forth.
And
so
that's
what do you do in that situation?
He
wants his fee, and it's a serious case.
Yeah, that's a perfect example of the principle we discussed earlier. Select a mediator who's experienced in this area of law,
good reputation,
and who's willing and able to help the other side understand your client's strengths and their own weaknesses, and help your client understand.
That's why we picked him jointly, because both sides thought the guy would do something. Mm-hmm. And it's terribly disappointing that, and the plaintiff's lawyer, who's a well-known plaintiff's lawyer in Birmingham, we talked, like I said, and he was as shocked as I was. He knew the guy better than I did, and he wouldn't do anything. Mm-hmm. I guess he just sorry. Lazy.
Well, and that's
we made him a big fee, he's supposed to be good.
That's a really unfortunate experience.
No
and whether it be because the mediator's not helping you, or because you've gotten to the point where the other side has put every dollar on the table, and you've concluded that it's not acceptable, then you've got to be prepared to walk away if you have to. And I want to tell you that we've seen cases where we walked out of mediation, and the other side had offered not nearly enough money to resolve the case. And we walked away, and we came back for more negotiations later and resolved the case for a very satisfactory sum. Well, these principles can be applied successfully. We've seen it done. These are some ideas, just some thoughts to share with you to try to help us encourage each other not to go into mediation just thinking we're going to settle the case, but we're going to try to get maximum value for our clients. And I want to, at this time, open it up. I promised you I was going to keep my remarks brief, but I want to get some of y'all, like Emory has done, who've had experiences to share with us what some of your experiences have been in mediation.
But sometimes you can never, you never know what the mediator's, really telling the other side. I mean, I've been at and he's holding his cards close and he goes back and forth and he does his job.
Yeah, you don't know for sure what he's telling you, but if he's an ethical and honest mediator, he's going to keep your confidences that you share with him, and he's going to be honest with you about what he shared with the other side that you've authorized him to share. So, yeah.
In that same mediation, an insurance company was involved. I was the defendant. They didn't represent us. And they didn't represent the plaintiff. I think the plaintiff had a bad faith claim against him. I'm not sure exactly how it all worked. But my experience was, and I'd be interested to know yours, is that insurance companies will just try to wait you out until, they won't offer a dime. And I told the insurance company at about 8 o'clock at night, I told them with curse words, get out and don't come back. And they stepped outside, and then the mediator said, no. I said, no, just tell them, go on, just go on, don't come back. About 10 minutes later, they came back and they started then putting some money on the table. I mean, if you're, generally with a plaintiff lawyer, defense lawyer, or insurance company, a good insurance company with a defendant will, they'll offer up something. But this company, they didn't offer up a dime until I talked to them.
Mm-hmm. Well,
have you ever had experience with them going so long? You start and they're not coming up?
well, we've had experiences where we've had to walk out because, they wouldn't offer a reasonable sum. And yet those cases have later resolved. If you follow these principles with developing the case, getting all the evidence, building the heat, putting together an effective visual aid for your mediation, talking directly to the other side, doing only incremental responses to their offers, sticking to your game plan, you increase the chances that you could resolve the case in that mediation, but it also increases the chances when they see you walk out and they know you're serious about trying the case, that the risk becomes more apparent to them, and it's more likely to...
It wasn't mine, sure. So, I didn't care about making him mad because he wasn't mine, sure. But, so anyway, it was about 8 o'clock. I said, well, we're going to go another hour. Y'all leave and don't come back tomorrow. Don't come back. And the plaintiff's lawyer agreed with me. And then they stepped out for 10 minutes and came back, and we didn't settle it, but we got there, eventually.
Started the real negotiations going.
Yeah. So.
Anybody else?
A couple of things I've found. First of all, I think one thing that's really helpful, especially depending on who you're dealing with on the other side, is have a conversation with me as the defense attorney.
Mm-hmm.
And you agree ahead of time and say, hey, the original sentence to mediation, who would you agree on? Whereas instead, and you're dealing with the judge, I want Matt Glover, because obviously he's plaintiff's oriented, they want somebody that's defense oriented on that. If you can agree ahead of time, I think you've got a lot better chance of resolving.
Yeah.
The other thing I think you've got to be very careful in picking your mediator. I had an experience earlier this year with a guy that has settled another case from this year. I think it's a wonderful mediator. But we took a fraud case from him. I think the problem with mediation was he never got our theory. I don't think he ever understood one thing about it. Mediation is unfortunately an expensive mediation. And it didn't have a good result.
Mm-hmm.
Those types of cases, this man's been very successful. So I think you got to know your mediator and kind of know their limitations.
Yeah, exactly right. Y'all are both singing 2 verses of the same song. Now, Matt's a masterful mediator. He could get ISIS to go back where they came from. Any thoughts?
I like the dog does.
There you go.
We definitely incorporate that.
One thing you should know